economic integration, and transnational nature of crimes. Those are areas that we really need to look into seriously and see how we can sharpen the skills of the lawyers we are training also to go into those areas. In this context, the role of lawyers is changing, the demands on our judiciary are evolving, and the expectations of the public are rising. Consequently, legal education must respond effectively to these demands. Dear colleagues, in addition to ongoing regional and global changes in Kenya, and increasingly across the region, the conversation about justice is also undergoing a profound shift. We are moving towards a people-centered approach to justice, an approach that puts the lives or the lived realities, the needs and the aspirations of individuals and communities at the heart of justice. What the people-centered approach to justice means and how it can be realized is that justice is not only found in the courtrooms. Justice is found, it's a lived reality, it's a common good. It is found in our families, in our communities, in the marketplaces, in the places where we worship. And therefore, this cannot just be realized without having judges, judicial officers, and lawyers who are able to adapt, who are knowledgeable and committed to furthering the ends of justice that becomes a lived reality in the lives of our clients, the people who come to us, and even empowering those people to know their rights and know how they can deal with issues that confront them. In other words, how can everybody, because everybody wants to experience fairness and justice, how can everybody become a champion for justice? So the formation of such a judge or a judicial officer or a lawyer begins in the classroom where they are taught. And this is where CLE and our universities come in handy, because I think we have to change the approach that we use so that we can refine our curriculums to fit this kind of a calling. If we are to take a step back and reflect about our legal education in Kenya, and indeed the entire East Africa region, we can all agree that tremendous progress has been witnessed. From a handful law faculties at independence to diverse ecosystem of law schools that we see today, we have seen expansion in terms of access to legal education. We have seen also specialization grow and the entry of new areas of teaching and practice of law. As a matter of fact, when I was admitted as an advocate in 1987, when many of you were not born, I was number, I think 1,700. Today we are over 27,000. I alone as the Chief Justice have admitted about 10,000, more than they were. Many decades. You can imagine the admission of lawyers from independence up to when I was admitted, it was 1,700. And you can imagine I've been Chief Justice for 4 years and 6 months, and I've admitted 10,000. So this is really exponential growth that we must appreciate, celebrate, and find a way of accommodating them. Because this growth is not a curse, it's a blessing. However, it has brought with it some complexities that make us sit here at this conference to address. But there are equally opportunities and challenges that you will be grappling with, but I believe the solutions are with us. The world into which we are training lawyers is today vastly different from the one that I was trained or that was contemplated when many of us were trained. Globalization has accelerated the mobility of commerce, capital, and people and ideas. Digital technologies have transformed how justice is availed and accessed, how crime is committed, and how evidence is gathered. Equally, regional integration under the East Africa Community and the African Continental Free Trade Area has expanded cross-border commercial transactions, creating new frontiers of opportunity, but also establishing new layers of vulnerability. This is why Professor is talking about us imagining the future all the time. And as we imagine the future, we imagine the opportunities, and we also imagine the challenges that come with that future. This expanding universe of opportunities and challenges require lawyers who are agile, who are globally literate, technologically fluent, ethically grounded, and capable of navigating the legal systems that intersect across borders and jurisdictions. Indeed, today's lawyer must understand not only the law, but the ecosystems within which the law operates. Increasingly, complex financial crimes such as money laundering, terrorism financing, and cybercrime call for competencies in financial intelligence, risk management, compliance frameworks, cybersecurity, and digital forensics. Cross-border transactions also demand proficiency in international commercial law, trade investments, protocols, and arbitration. The theme of this conference, Legal Education and Training for the Globally Competent Lawyer, reflecting on the past and charting the future, therefore invites us to take stock of where we have come from, while boldly imagining where we must go. It demands that we recognize that the next generation of lawyers will not be defined merely by professional credentials, but by their adaptability, resilience, and capacity to address problems in a world where change is constant and complexity is the norm. From the judiciary's perspective, the future of legal education is deeply intertwined with the future of access to justice. Our blueprint, the social transformation through access to justice, calls for a justice system that is people-centered, that is responsive, that is technologically enabled, and that is grounded in multi-door approaches to dispute resolution. Colleagues, next door, we have a convening of about 500 judges, judicial officers from the East Africa community converging here in Nairobi to explore how we can use the multi-door approach as a means of accessing justice for our people. Under Article 159 of the Constitution, we are mandated to promote alternative forms of dispute resolution. And as you know, the judiciary is scaling up court-annexed mediation. Indeed, we are now at 46 counties having registries for court-annexed mediation. We are also scaling up the alternative justice system. This is an organically grown program where we are helping communities to resolve their own disputes. We've already established NJS suites and forums in 13 counties. It's a very labor-intense program of training people on NJS because we have it rooted in our African customary laws. We knew how to resolve our disputes in many communities, but as you know, unfortunately, when we were colonized, our systems were declared repugnant, and therefore we were forced to adopt common law. We've been struggling with this common law. Next door, we were told the developed world has adopted the alternative ways of resolving disputes. As a matter of fact, we were told in the United States of America, 95% of their disputes, including criminal, are resolved through the alternatives. It's only 5% that go to the formal justice system. This conference, therefore, is a platform for enhancing clarity, alignment, and shared resolve in addressing these challenges. There are also remarkable opportunities before us. With the growing digitization in our courts and also in the legal profession, we have a chance to embed digital literacy at the foundation of the legal training. With the rise of artificial intelligence and automation, the legal profession can evolve to focus more on analytical, humanistic, and relational competencies. AI should not threaten us because it cannot take part in understanding the background, the context within which we work. It cannot replace empathy and care. Therefore, as you engage in this conference, I encourage you to imagine a future where legal education is interdisciplinary, where legal education is technologically empowering. It is experiential in nature. It is ethically anchored and globally connected. A future where law schools, professional regulators, the judiciary, the industry players, and international bodies collaborate to shape a holistic lawyer. Recently, the Supreme Court took the challenge when we hear that the universities are producing half-baked graduates. We asked ourselves, how can we come in to support and mentor students from the universities? And for 2 years learning, we've been doing a moot court by the Supreme Court where we call the law schools, the universities, to bring students to debate. And the last debate, which happened only a month ago or 3 weeks ago, was on very complex international issues. And the way I saw those students robustly debating, arguing their cases, the memorandums that they prepared, I am so confident that the universities are doing a good job, and we commend you for that. So let also the private sector step in and see how we can help the universities mentor and sharpen our students. So as I close, I urge all of us to embrace a bold and collaborative approach to reforming our legal education. Let us commit to strengthening quality assurance mechanisms, modernizing our curricula, integrating practical skills and ethical instruction, expanding clinical programs, and establishing stronger bridges between academia, the judiciary, the industry, the bar, and everybody who cares about having a legal profession that thrives. Let us place integrity at the heart of training, for no amount of knowledge can compensate for the absence of ethics. Importantly, let us remember that in shaping the next generation of lawyers, we are also shaping the future of justice in Kenya, in the region, and beyond. I thank you all for your attention, for inviting me, and I wish you very, very robust and successful deliberations. I don't know whether I'm supposed to declare this inaugural conference open